Let us begin with a question that is uncomfortable but necessary. How many crimes do you think are committed against children in our country? The numbers are deeply disturbing. In 2022 alone, reported crimes against children in India crossed 1 lakh. Of these, nearly 40,000 cases involved sexual offences against children. What is even more troubling is that this number continues to rise every year. Now pause for a moment. The age at which a child expects the highest level of safety and protection is also the age at which society has repeatedly failed to provide it. This brings us to a fundamental question. Do we have a law that can protect children effectively, punish real offenders strictly, and still ensure justice is delivered fairly? To explore this, we need to understand the Protection of Children from Sexual Offences Act, commonly known as the POCSO Act, and the debate that has emerged around its application in recent years. This discussion is not about legal technicalities. It is about intent, impact, misuse, and the difficult balance between protection and justice. The POCSO Act came into force on 14th November 2012, a date observed as Children's Day. It was introduced to address serious gaps in the existing legal framework. Before POCSO, sexual offences were dealt with under the Indian Penal Code. That framework was broad, not child-specific, did not treat children as a distinct vulnerable group, and was not gender-neutral. POCSO changed this. It defined a child as any person below 18 years of age, irrespective of gender, and criminalized all forms of sexual activity involving minors. This is directly connected to the concept of age of consent, which in India is fixed at 18 years. Below this age, consent is legally irrelevant. The intent of the law was clear: to protect children from sexual abuse, exploitation, and predatory behavior, and to deter such crimes through strict punishment. However, over time, courts have encountered a more complex reality. Sometimes, laws, despite having the right intent, do not fully align with changing social conditions. Today's adolescents grow up in a world shaped by social media, early exposure, and rapid access to information. This has accelerated maturity in ways earlier generations did not experience. As a result, a reality exists that cannot be ignored. Many adolescents between 16 and 18 years of age are involved in mutual consent-based romantic relationships, sometimes including sexual intimacy. Under the strict application of POCSO, even these situations are treated as criminal offences. This creates a paradox. A law meant to protect children sometimes ends up criminalizing adolescents themselves, even where there is no abuse, coercion, or exploitation. This is not unfamiliar in legal systems. Laws often require interpretation and contextual application. For instance, under juvenile justice law, minors who commit particularly grave offences may be tried as adults if they demonstrate sufficient cognitive maturity. Here, the law acknowledges that context and capacity matter. This raises a difficult question. Can similar contextual discretion exist to prevent unnecessary criminalization under POCSO? This question has gained urgency because of another concern: misuse of the law. Courts across the country have observed that POCSO is often invoked not to protect children but to penalize relationships that families oppose. Inter-caste relationships, inter-religious relationships, and adolescent relationships that defy social norms frequently become targets. In many such cases, the complaint is filed by the girl's family. In some instances, the girl herself is pressured to support the allegation. A commonly observed situation highlights this issue clearly. A girl is just a few months short of turning 18, while the boy has recently crossed 18. Despite minimal difference in maturity, the boy is prosecuted as a sexual offender. This has led courts to recognize that the law is sometimes being weaponized, turning POCSO into a tool of moral regulation rather than child protection. In response, several courts have begun adopting a context-sensitive approach rather than applying the law mechanically. One significant development came from the Allahabad High Court in May 2024. The court noted that age manipulation is a recurring issue in POCSO cases and suggested early age determination to establish whether the law applies at all. Although the Supreme Court did not make this approach mandatory, it acknowledged the broader concern. The Supreme Court clarified two important points. First, the age of consent should not be reduced. Second, the center should consider whether limited exemptions could be introduced for close-in-age, consent-based adolescent relationships. This proposed idea is often referred to as the Romeo-Juliet clause. The intention is not to dilute child protection but to prevent over-criminalization in cases where there is no abuse or exploitation. Several high courts, including the Calcutta High Court, have recognized that not all POCSO cases involve sexual violence. Many arise from mutual relationships, and ignoring this reality would mean denying observable social patterns. At the same time, strong opposition exists to introducing any exemptions. Critics argue that consent below 18 cannot be considered meaningful. Minors, they say, lack the maturity and independence required to assess consequences. Consent at that age can be influenced or manipulated, particularly in situations involving power imbalance or false promises of marriage. Supporters of strict enforcement also cite data indicating widespread sexual abuse of children, arguing that any dilution of the law could weaken protection. Concerns have also been raised about legal ambiguity. Once exemptions exist, they may be invoked in many cases, potentially allowing genuine offenders to escape accountability. Others warn of a slippery slope, where exemptions gradually expand, lowering protective thresholds. There are also practical challenges. Assessing consent requires sensitivity and training that law enforcement may lack. Courts could face increased burdens and inconsistent decisions. This is where the debate stands today, between protection and autonomy, between deterrence and discretion, between the letter of the law and lived reality. The discussion around POCSO is no longer only legal. It reflects broader social change and generational tension. And the challenge ahead remains unresolved. How do we protect children effectively without causing injustice in the process?